I think your last name, Xynnis, Nick Xynnis, I think you get in the media because people love spelling your name.
I don't know that I'm in the media that much. I mean, other than in Sudbury, where I seem to have a bunch of cases. I don't know. People have fun pronouncing my name or mispronouncing my name, and I have fun with it. It's not a big deal.
Well, it's kind of epic. It sounds like it would be the title of some sort of sequel for the Avengers or something. Next episode, Xynnis. But
Whenever a judge sees my name and goes, how do you pronounce that, or how do you spell that? I always go usual spelling, usual pronunciation. We have
uh,
a laugh.
I like your whole courtroom scenario going on in the background there.
Yeah, I don't want people to see my messy office, so I put up
Yeah.
this fake Zoom background.
Well, I think messy offices are good. It shows that you're working hard. No?
still, still.
Even in COVID times, I know a lot of people think that trials aren't going on right now, but obviously they are.
In many ways, I'm busier than ever. It's silly.
Did you say anyways?
In any way, if I said anyways, I may shoot myself. Um,
Well, you've driven me mad over that word because I went up to Sudbury
no,
with you.
no, I said in many ways. In many ways, I would
In
never
many
say.
ways.
Yeah,
Okay.
I would never say
Because
anyways. That would be absolutely ridiculous. In many
so
ways,
here's what happened with us, right? Like we spent a whole like 2 trials in Sudbury together. And anytime I said anyways, I'm like, anyways, and then you go, what?
I think you meant to say anyway.
Yeah, because anyways is
Does not
improper.
exist. It's not a word. I don't care what anyone says. It's become a colloquialism. It's been accepted in some dictionaries, but it's not a word. It's anyway or in any case. But anyways, you might as well start saying use guys.
Use guys. Well, or you Utes. The two Utes.
Fair enough.
I know. So, well, actually, thinking about Sudbury, what a crazy time. That was a case that did have a lot of publicity on it that I was helping out with. And so the two of us go up to Sudbury, and I'm not going to even talk about your windshield wipers and what's wrong with them
I've
because,
changed them. I've changed them. I've replaced them.
oh my God, did you really? Okay, I'll get in a car with you again. um, so we go up to Sudbury and stay in this hotel, which was actually quite nice, but and it was directly across from the courthouse. So it was easy to go back for lunch, if we wanted or whatever. It was just super convenient. But it was kind of a bizarre situation because there was like same guy, two different trials. And that hotel, while we were staying there, they had a pool, which I wanted to use because I wanted to stay healthy and all this other stuff. But every time we got back, because you happen to know this amazing restaurant there, so we went there every day. And then by the time we got back, the pool was closed. And so the very last day of our stay, I finally just turned on the shower and started swimming in the shower, pretending that I actually made it to the pool one day. And I posted about that. And yeah, I actually did it. And I can tell you, it was very satisfying.
Remember you telling me that? Yes.
I know. But no, you know the best restaurant. Let's give a plug for them actually, because they're pretty amazing. What's the restaurant name?
Alexandria's.
Alexandria's.
Yeah.
Yeah.
If ever you're in Sudbury and you're there for business pleasure passing through, go to Alexandria's. Best restaurant. I think almost anywhere. Definitely the best restaurant in Northern Ontario.
But okay, so thinking about the Sudbury thing, and let's get a little serious now. Both of those cases are going into appeal, right?
Right.
And the second one, I think, is the most disturbing because it ended up being one complainant who said that her sole memory of being sexually assaulted was a body memory, that the body never forgets kind of thing, that she had in the middle of the night an epiphany. This is from the record at the trial. And that she had that her body somehow remembered what had happened to her while she was unconscious. And so of course that's an issue in terms of, it brings up concerns about lessons we've learned from the past about recovered memories.
Sure. It was. I think it was a horrible decision by the judge, and hopefully, uh, I can convince the Court of Appeal to correct it. But essentially, the evidence was that she was evening at my client's place with another woman, and whatever happened. She had a dream, apparently, about what happened, that dream moved into a flashback, became a flashback. But the most important thing of all is that she, on both examination chief and cross-examination, she admitted, said, testified that she was asleep or unconscious or not aware of what was going on from one moment till she got home. So basically, she's there, she's drinking, she falls asleep, she passes out, whatever happens, and then she wakes up hours later, getting out of my client's car, walking to her home. So the ultimate question is, how does she remember what happened when she's not awake, when she's not aware? We can't be aware of our surroundings when we're asleep or we're unconscious. Things were going on, whatever was going on about her, if anything was going on about her, she wouldn't be aware of them. She wouldn't be able to appreciate them. Yet the judge accepted that she had a memory of it.
Well, I remember during the trial that the judge said that she was aware that this was not expert testimony and that she was very intrigued by the language being used. And so another appeal just went to Supreme Court, which reinstated convictions. That is very concerning because they said that, well, no, I don't know about concerning, but it raises questions about expert testimony. Because I remember in Sudbury, the Crown acknowledged that she wasn't calling an expert. And there's limitations on what experts can do anyway. But what do you think we should be doing with situations like this? Because I'm afraid that there's so much pseudoscience being promoted on popular science magazines and by journalists and so on, because they're intriguing stories, the idea that the body never forgets and things like that. These are really catchy phrases. But what does that do in the courts of law? Because I'm seeing a lot of this kind of language being used in court now.
Well, experts are there to assist the trial of fact. And if you can call an expert to say, yeah, this woman had this experience and she'd be able to remember it later, even though she was unconscious or asleep, then fine, call the expert. The fact that you can't call such an expert because no such expertise exists, it leads to an obvious conclusion that you can't accept that evidence. So,
well, that's the problem, is that you're being asked to prove a negative in a way.
Exactly. And in so many cases, experts aren't being called because they're not of any value. You can't call an expert to say this person would remember this in this way, or this person did this, and so because of that, they should be believed. Sometimes all an expert can do is really just comment on the surroundings and circumstances that would affect memory or affect cognition or affect appreciation. That sometimes can be helpful. I think you're talking about the Waterman case in British Columbia, in Newfoundland, that went to Canada.
It was East Coast.
It was Newfoundland, yeah. So in Waterman, in that case, if I remember correctly, the complainant had given a number of different explanations, a number of different versions of what happened. I think let me quickly look at the judgment. I pulled it up earlier.
Well, that's the thing with these cases too, is that you have to kind of look at the original decision so that you can see all of the details of what's involved. But my recollection is that the complainant, who was male in that case, his story changed drastically. It actually got less dramatic, I think, as time went by.
Exactly. And here's a very quick summary. So he tells the police the first incident was involved a car ride. At trial, he said it was a motorcycle ride. That alone, to me, says, what the hell is going on here? You don't mistake a car ride for a motorcycle ride.
They're vastly different vehicles. Yeah.
Then he goes on to say that he asked for a motorcycle ride and that the accused hemmed and hawed. And then he later says that it was the accused's idea. All sorts of, these may seem small, but cumulatively, they make one wonder, well, what the heck's going on here? And people have to understand, a trial is not necessarily a search for truth, a search for an ultimate truth. Sometimes we just don't know what happened. And in that case, the benefit goes to the accused. And in the Waterman decision, the first discrepancy alone tells me I can't be certain to any reasonable certainty what happened here. So when you add on all the other ones, though, in the case, I think the Court of Appeal of Newfoundland did the right thing. Canada came back and said, no, it's a jury's decision, and we have to respect it. Well, the appellate courts have never seemed to have trouble in the past changing jury decision when they found it to be unreasonable. And to me, this was one that was clearly unreasonable.
Well, the majority of the Court of Appeal agrees with you. So,
yeah, and two judges of the Supreme Court.
Well, like you say that a trial is not a search for truth, but there are a lot of rules of evidence.
It's not necessarily a search for truth. The trial will not always come to an actual truth of what happened. Sometimes a judge is left with, you know what, I don't know what happened here.
Yeah, well, I get your point that, like, a lot of times in these cases, the ultimate conclusion is that we can't know what actually happened. Yeah. So it's like, I would say that it's not a search for a definitive answer of if an assault happened or if it didn't happen. It's a search for what can we know. And that search has to involve an agreement on what constitutes a fact, I think, is one of the ongoing issues that I'm struggling with when you look at some of the postmodernist ideas, which there is postmodern legal theory, right? So this is something that's being injected into or proposed for our system, that there are no facts, there's only lived experience. And there's some points to be made with that. I don't want to get too far into all the lingo and just turn it back to you again for your thoughts on all those issues. But there has to, I think there's an agreement that many people can be in the same room and see different things and think that something different happened. Absolutely. So how do we translate that into a fact-finding process?
The system we have is the worst in the world until you compare it to all the rest, to paraphrase Churchill. We just use the system we have: examination, achievement, cross-examination. And I was reading some of the articles you sent me on repressed memories and witnesses' appreciation and so forth. And there was one really good judgment which talked about how sometimes you really can't rely on eyewitness or an individual perception of what happened. But what's important is their answers on cross-examination, which will inform you as to what influenced that person and how they perceived what they perceived. So again, cross-examination is the best tool if conducted effectively and professionally in getting as close to the truth as possible.
So why is that? Because I'm finding that we have to explain a bunch of established understandings about legal systems and what makes some better than the others, but people don't understand why cross-examination is so effective. Why is it the best tool?
I've been in the system for 32 years, so I have a bias. I'm not about to say that the adversarial system or some other system isn't better, or the military system of justice is better. But I think cross-examination overall in every legal system has shown the most effective method of discerning the truth or the reliability and credibility of what a declarant is saying. And why? Because it challenges the person. It forces the person to look at, examine what they're saying, and not just the expression of what they're saying, but the core, the foundation, the circumstances, everything about it. Oh, I didn't appreciate that I was that far away. Well, I didn't appreciate that person had that distinctive characteristic at the time. So it helps inform that person's, the witness's knowledge even more fundamentally, and sometimes makes them reconsider. Rarely, very few witnesses will recant, but sometimes they will. But for the most part, it helps the judge understand why that evidence is the way it is and whether it should be relied upon.
Yeah. Well, I mean, that was obviously a very complicated question that could take a long time to unpack, but obviously it can't be simplified. I think that confirmation bias is a major problem. So, So this polarized vision of how things work in the world that we're looking at right now, I think that's one of the reasons people don't understand it, is that by cross-examining something or somebody, you're not starting out by saying you're lying. There's also the approach of, are your memories accurate? Right. So
Absolutely.
it's not just credibility, it's reliability. And I think that everybody has this stereotype about, what lawyers are intending, because we have this whole thing about whacking witnesses and stuff like that. And so everybody assumes that there's only one function, that a complainant comes in telling the truth, and a defense lawyer comes in and tries to upset them enough that they end up being shaken. you know,
That's that's very rare. That's rare. Those moments are few and far between.
I know, but everybody thinks there's like Perry Mason moments and stuff like that that go on in trials, and it's so not like that. I mean, it's almost tedious sometimes trying to.
It's not almost tedious. It is. It's it's you're basically approaching the person from the periphery, moving towards the middle, and sometimes if you can just chip away at the edges, that's all you can do. Sometimes you can go a bit further, but just chipping away at the edges of a story, the edges of the person's perception or knowledge is the best you can do. The reality is people rarely will recant, will say, will admit to being wrong, whether it's their perception or their knowledge.
Yeah, well, the foundational principles behind how we designed our system, I think it's really important to explain them to people. Like, just last night, I saw people talking about the Blackstone Principle, that it's better to let 10 guilty men go free than to convict one innocent. And I've come to see, but it's my understanding from how people present that with outrage, that they actually think that we're making some sort of a deal, that, okay, you know what, let's barter. You pick 10 guilty guys and we'll let them go free just so that we can save one innocent guy. Like, they actually think it means that we're agreeing to let 10 guilty people go free. Yeah, you know what I mean?
Yeah, I mean, I've used that expression too, but my favorite way of explaining our system is it's a system of laws, not a morality. Morality has almost nothing to do with the criminal justice system. It might inform the laws. It might help the legislature decide what law to enact or how to draft the law. But morality has no part to play in the result in our case. All I care about is whether the state can prove my client guilty beyond a reasonable doubt. If they can't, leave him alone. He may still be guilty morally, but that's between him and his God.
Yeah.
It's not between him and the state. This is just between him and the state. What people do is they confuse the relationship a person might have with his God, creator, or whatever, the moral relationship that person has with the crime, as opposed to the legal relationship the person has with that crime. And the two are completely separate.
Well, I think also that there's a lot of misinformation about what it means to be incarcerated, so that people don't understand, how serious a loss of liberty is. Because
it's horrible. It's horrible.
Yeah, I mean, I've read journals from guys who just spent like 10 days in jail before, and it's devastating, and it creates, a real trauma for them, especially for innocent people, and the loss of control over your own life, and the dependency. I think that's an interesting thing too, is, having come at this from an advocacy point of view, where I've mostly started speaking to people who've been accused, and then started speaking more to lawyers, that it's really difficult for them to cope with the fact that their life and their future is in the hands of somebody who they potentially just met, they know nothing about.
Right.
So that's where you come in. And
again, it's a system we have. It's not perfect, but I'm not sure how else it's going to work. Hopefully the lawyer you retained or is assigned to you or whatever is committed and dedicated and hardworking. Most are, but lawyers aren't perfect. It's like any profession, any job. There's a few really good ones at the top, a few really bad ones at the bottom, and a whole bunch of, I wouldn't call it mediocre, but individuals who try hard, work hard, and generally do well, but sometimes do not. So
Yeah.
that's all you can do.
Well, I mean, so many people have never been involved in the justice system at all prior to being charged with something that, I think that's why it's valuable to put as much information out as possible about how the system works and why it works that way, and what the language means, and also getting to see that lawyers like getting a sense of what it is they're juggling with, because that's one of the most frustrating parts is that it takes so long to get through the system. And then I've heard people say, my lawyer had a preliminary hearing and I wasn't even there and he didn't even tell me what was going on, but it turns out it was actually just a JPT, right? So all these meetings that take place, and they're like, why are there so many meetings, and why does it take so long to get a trial? And it can be so frustrating for people. And in the meantime,
I try to keep my clients informed of every step, but I mean, I'm not perfect, and so sometimes I'll forget or neglect. But yeah, it is important to educate them, and I try to do so from the very beginning. At the very first meeting, I'll take them through the process of what is going to happen step by step from the first court appearance right to the end of the case. Not that I don't predict what's going to happen. I say this is the process, and this is likely how long it's going to take. So that by the time they leave my office the first occasion, or by the time I first meet them now and virtually, they understand. They hopefully have some understanding of what the process involves. And the process it does have a certain amount of checks and balances. I mean, I represent the defendant, the accused. The Crown represents the state, but the Crown's obligation isn't just to get the conviction. And reasonable and decent crowds, that's the overwhelming majority of them, will often see things the way I see them and agree with me. Not always, maybe not usually, but often enough. And then there's the judge, who's also supposed to be a kind of a check and balance. Again, that doesn't always happen. It probably should happen more often, but it's still there.
How are you feeling about the opportunity to use Zoom for hearings and trials? Because I think there's a lot of minor issues. Leave aside whether a trial is better over Zoom or in person for now, but there's a ton of these little meetings that can now take place without you having to literally go into a courthouse, sit around all day and wait for a 5-minute set date or something like that, right? So I think there's some really, really good improvements on the system. And then there's the issue of the actual trial, where a lot of people are worried because, and this was my position at the beginning, is there has to be a human element where you have people in a room and understand somebody's life and liberty is at stake. But on the other hand, having done Zoom trials now, been there for them, you can actually see people better when they're testifying. And I don't know, what are your thoughts on whether Zoom is a potential valuable tool for the system going forward?
It's like anything else. There's good and bad and indifferent about it. I think it's great for set dates, administrative appearances, even bail hearings, and for motions and applications. Any type of legal issue, I think it's really, really good. But for an actual trial, I've done a few trials. I won one, lost one, another one in the middle of the trial. I had my client change his mind and plead guilty. So I've done them all right now. But for an actual trial, I much prefer individuals to be present, all in the same room, looking at each other, understanding, feeling each other, not a physical sense, obviously. I think that's preferable. There's a certain dynamic that's important, and there's a certain majesty that's lost over Zoom. Now, having said that, that may not be possible for some time. Secondly, if it's solely a legal issue, which doesn't really rely on credibility, reliability, then I have no problem doing a Zoom trial. I did one up in Bay not that long ago where the issue was possession for the purpose of trafficking, and really the issue came down to, was the circumstantial evidence sufficient for the to establish possession for the possession of the drugs, and there really was no other issue. Our clients didn't need to testify. The credibility and reliability of the officer's observation wasn't in question. Something like that, this is perfect because the judge is dealing with a legal issue. But if it's a matter of credibility and a reliability, what the person says, although demeanor is not as important as it was once thought to be, again, I think it's better to be there in person with everyone there. Uh, it's important for everyone to take the matter seriously and for the system to impart the seriousness of what's happening for the occasion. Now, when that's going to happen again, I'm not sure, but that's
Well,
overall my view. It's still
yeah.
early on though. We've only been doing this for less than a year. Still early on. I don't know what's going to happen. I don't know how it's going to end up.
Well, I think there's the solemnity and the seriousness of the issue that is achieved when somebody actually has to go into a courtroom, and the environment that's created there was like when you take that oath to tell the truth, it means a lot more. You're a lot more nervous about lying. I think that that solemnity is really important to understand the gravity of what you're saying. On the other hand, with the COVID situation and all the conditions in place, using a courtroom right now, having to go in and putting masks on, and there's no side rooms for you to go talk to your client in privacy and or privacy, as the British would say, that it actually is better to have a Zoom trial if you were otherwise forced to go into those conditions with all this plexiglass around everybody and you can't hear anybody and you have to keep repeating. And of course, the people who are employed, the court clerks and so on that work in the courthouses have concerns about their health and so on. But if you compare those two situations, then a Zoom trial would be much better. But if you compare a Zoom trial to a normal trial without all of the masks and plexiglass and all the other stuff, then absolutely there's no replacement for the sense of having the right to face your accuser. I mean, given some people can testify through CCTV or whatever for various reasons,
Sure.
but you understand the importance of what you're saying, and the seriousness of it is again tied back to understanding how drastic it is to take somebody's liberty away from them.
I agree entirely. Absolutely. We'll see how it ends up. I mean, I did a few trials early on last summer before we really moved into Zoom, and it wasn't that bad. They're up in Sudbury again. The court was basically set up so that where everyone sat, they were partitioned with plexiglass, and there was lots of hand sanitizer and Kleenex and bottled water available, and no one who didn't have a mask could come in front of the bar, but you never got close enough really to infect anybody or even at all. And the clerk and the judge were always a distance away, so it worked out fine. And I didn't find it to be all that bad. The most difficult thing was, again, speaking with my client. If I wanted to, this fellow was in custody, so I'd have to go to the prisoner's dock and talk to him. And I did it, although I did feel a bit uncomfortable since at some point we both have to take off our masks and speak to each other just a few inches away, because I don't want anyone to hear what he's saying to me and what I'm saying to him. So that's imperfect, and maybe something like that can be worked around. I mean, when you're doing Zoom trials, it's actually pretty good, because if you want to take a break and speak to your client, you just ask the judge, can I be put in a breakout room with my client? And it works out quite well. 10 seconds later, I'm in this virtual space with my client talking. So it seems to
be. But then, of course, we've seen when people think that they're not on camera, then they end up being on camera, or the audio is still working.
Yeah, those things will happen, but I mean, that's usually because they forgot to leave. They've got to mute or to black out their screen. If a clerk is putting me in a breakout room, then usually I'm okay. If a clerk makes a mistake, then and everyone hears what I say to my client, and it's so important that it's going to affect the fairness of the trial, then I can get a mistrial.
True enough. Yeah. But, I think it's always good habit just to wait for at least a few seconds to make sure that you have
for sure
that you're separated out and so on. Now, what do you think about, let's get away from actual trials that you've worked on. Today is the first day where we're not supposed to leave our homes again. right? With COVID new lockdown conditions.
I did today what I've done every day since the beginning of this pandemic. I drove from my home to my office. I live alone. I drive to my office alone. I park in a half-empty underground parking lot, and I walk through a completely empty path in downtown Toronto to my office. I take an empty elevator up to my office, and I walk down an empty hallway to my office, and I sit in my empty office for whatever period of time I want. So I'm pretty socially distant no matter what. I don't think it's a good idea to all of a sudden have the police stopping people arbitrarily going to their homes or businesses. In fact, I think the acting chief of police said that they won't be doing that. So I think that's a bit of an overkill.
Yeah, I think as a journalist, he started a Twitter thread listing all of the police services that said that they weren't going to do the spot check, stop and ask why you're out of your home and so on. But I think
if they see a group of youth hanging out someplace, they probably would approach them the same way they would whether there was a pandemic or not. So I have no problem with that.
Well, I think that part of the problem is that, and, you and I are hermits because I have the same kind of thing. Like, I just, nothing about my lifestyle has changed because of the pandemic, right? Like
I'm not that social. I do have friends. I do like to socialize. I go to dinner. I go to the pub. Okay, now my social life is I go visit my mom and have dinner with her, leave at 9 o'clock, and she asks me where I'm going, and I say, home. Where am I going to go?
Yeah. But, no, that's true. You actually do have friends, whereas I do not, for very good reasons.
I don't want that. I wasn't implying you don't have friends.
No, there's a good reason for it. But it's been a year where we were supposed to have just a couple of weeks of lockdown. And of course, we're essential service, anybody who's involved in the legal system. And, there's some things you can do from home, but many things you can't. But for a lot of people, they simply can't do their job from home. And all those people are struggling right now. And then instead of like a year later, the problem is that it's not consistent. They start opening things up. People invest money to try and start their business again. And then after investing the money, all the rules change. And so we never know. It's like being on a puppet string or something. I understand why people are angry.
It's frustrating, absolutely. And I also understand the government's approach. No one's had to go through this for about 100 years. I don't profess to know what the balance is. I just have to deal with what I have to deal with. I think the most important thing is to wear our masks and be distant. That's about it.
Well, I mean, from the beginning, I have had a little bit of, that whole like herd immunity kind of feeling for myself, but I've, tried to respect that. Like, I don't want to put anybody else at risk. And there's, a lot of people.
And we've got to get immunized as well. So I've had my shot, and I know millions have already. And that's also really important. And hopefully, as that progresses, that'll lessen the rest. That'll reduce all the other negative consequences that we're having. Sorry to interrupt you.
No, that's fine. I mean, it's a difficult situation because I understand both sides of it. Where there's a lot of attention on down in Florida right now, where I can't remember if he's their governor or their mayor or whatever, but governor. Yeah. So, he's had his own theory about how to deal with it. And he's gone forward, with a specific purpose and the ability to keep moving forward. I think this is one of the issues with democracy, actually, that sometimes you have to pick a path and then follow that path. And with democracy, sometimes you end up picking a path and then verging back again, and then nothing gets accomplished because you can't actually make a decision and then follow through on it. Is that making sense? Do you understand what I'm saying?
Yeah. I don't have an answer. I don't have an answer.
Like, it's
Yeah.
frustrating, I think, even in a bigger picture, with, let's say, an economic plan for the country to try and get the country out of debt or something like that. And then say the conservatives in Canada get elected, and then they initiate a plan because they think they can actually solve the goal, but it's going to take a long time to do it. And then they get ousted in the next election, and the liberals come in, and then they reverse everything, right? I kind of feel like that's what's going on with the COVID plans, where we're saying, like, Theresa Tam, don't wear a mask, only sick people should wear a mask. And then all of a sudden it's like, all of you should be wearing 2 masks, right? And so because it keeps going back and forth, and they're saying, things are getting great, and then it's going the other way, and they can't control, what's happening in terms of how many people are actually getting ill.
I'm not an expert in this stuff. I'm forgiving of them, because the knowledge has evolved and has grown. I think they're trying to do their best. It just is what it is. I don't know. I'm not sure what else I can tell you.
Well, I mean, that's the thing too, is I don't think that there's any leader who could have made the right decisions all the time. I think that no matter what it is they did, that they were going to be, criticized for doing the wrong thing. Now, of course, we're looking at with the lockdown, because that's a practical consequence that's getting, a lot of people are talking about this is illegal and stuff. So that gets into, constitutional issues about how far can they go. And there's a bunch of challenges going on, especially with the churches and so on. And
I suspect that almost every challenge will be defeated under Section 1 as a reasonable limit. I'd be surprised if that's not the case.
Yeah, well, I don't think people understand the Section 1 issue. So maybe can you explain that a little bit, what Section 1 does and when it's successfully employed?
Sure, I wasn't prepared for this, so let me see if I can quickly look.
Well, I know,
up.
but you're like the expert on everything, Nick. That's why you're my friend. I can call you and just ask you anything.
I really don't know about that. Just give me a second here. I want to make sure I get this right. Okay, so.
Yeah, it's better to get the proper wording, like the full wording, but it's like, so you have all of your rights. First of all, you have all of your rights under the Charter that are guaranteed in a free and democratic institution or country, right? So there's values.
So Section 1 says, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The key of that section is that subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So it's basically a 3-part test. 1, it's got to be a reasonable limit. 2, it's got to be prescribed by law. So it can't be just some dictate by the mayor or the premier or the prime minister. It's got to be promulgated by a legislature or parliament or put in a regulation properly. And then it's got to be demonstrably justified in a free and democratic society. So to my mind,
part of that is that it's minimally impairing.
Well, yeah, now you're moving into the case law on this, and I don't propose to do that. Yeah, that's one aspect of the courts have now read into that, which is that it's got to be minimally impairing. I think it's going to be difficult for any court to say, we're gonna decide that the government was wrong, if this was not minimally impairing, or this was not demonstrably justified in a free and democratic society. I think the courts, especially in Canada, will defer to government in such in a pandemic. In the States, it's different. The Supreme Court, especially there, seems to always hold, not always, recently seems to be upholding religious rights over other rights. But that's their jurisprudence. Here, I'd be very surprised if a court overturned any meaningful restriction related to the pandemic.
Well, we're not just dealing with hypotheticals, and you can't say that a dead body is a hypothetical dead body when there's actually like people dying of it.
Yeah, exactly. Yeah. So, if it ever got a meaningful court challenge, the government would the state would bring out all the separate evidence about what's happening in our hospitals or ICU units, about how the medical system being overwhelmed and stressed and this and that. and that would be the justification. That would be what demonstrably justifies this in our free and democratic society.
Yeah, I think one of the problems that that I've watched growing over the last decade or so, maybe even longer, is that the internet has created a breeding ground for conspiracy theorists, and so that's been one of the problems. And then, of course, with the internet making it more difficult for the media, that information sources, and the lack of faith, the lack of trust in our sources of information has been one of the biggest problems during this pandemic. Yeah.
Absolutely. And before the pandemic, and it will be afterwards. There's no longer, for too many people, there's no longer an accepted source of information or news. Or at least, how can I put this? Well, before in the past, the overwhelming majority of society would agree that, what the CBC or CTV or NBC or CBS or ABC tells us is generally accurate within a certain amount of, within certain parameters. And now everyone questions everything all the time, and you get all sorts of variations of what might be the truth and what might not be the truth. I don't have an answer. I don't think, as a former reporter, I'm loath to censor anybody or anything. I believe in the marketplace of ideas, as described by, forget, I think it was Wells who wrote on liberty. At the same time, it's difficult for some people. It's really difficult to discern what is the truth. I mean, if you're watching Fox News all the time, then you won't know anything about anything.
Well, I know, and I'm an advocate for unfettered free speech as well. I think that counter speech is the most effective, way of dealing with speech that you don't like. So, but of course, there's some speech that has consequences when you get into like defamation or things like that. So, I mean, that's a whole other subject that could probably, take up hours of conversation, and it gets litigated all the time. But I do think it's interesting how people's obsession with true crime and shows about the law and so on has kind of somehow integrated into like our online communities, where people have taken the law into their own hands. They think they understand the law really well. And that's why I think it's so important to have lawyers actually explaining legal principles and so on. And I know there's like the whole court of public opinion going on in a lot of cases too. That well, what's it like when you're working on a case, as you have, that's being reported in the media? What are the issues that come up? Because I would think if you had a jury trial, that it's very difficult to get an impartial jury if you have a lot of media attention.
The jury trials I've done have not been anything particularly notorious. I did one very notorious trial. I acted as counsel one very notorious trial years ago, but that was a judge alone matter. It was I represented a grandmother who was found guilty of killing her grandchild by starving him to death. She was found guilty of second-degree murder. But that was a judge alone trial done over a period of time. It got a lot of attention, but it didn't affect the way I did my trial or my co-counsel, I don't think. In Canada, we're just not as sensational about this stuff as we are in the States. I mean, trials get attention, they get reported on, but that's about it.
Yeah. Well, I think we do have.
Maybe I'm being a bit naive here, but I haven't noticed anything more.
I think we do have really good judges in Canada that separate out the stuff that's not a proper part of the trial and so on. At the same time, it seems pretty clear through a lot of their reasons, especially in high-profile cases, that they acknowledge public pressure and sometimes address it, saying, "I understand that there was a really great decision in the case of the high-profile case of the 3 Toronto cops in Toronto, that Justice Molloy, I think I always say her name wrong, Molloy. She had a brilliant little segment that she wrote because she was aware of the publicity and so on, and the hashtag Me Too movements. And she explained why that's not a principle in law and why it can never be a principle in law. And that, starting from believing is not a principle that can be adopted in any reasonable court. So very clearly, even though she did a great job explaining it, and she ended up acquitting and so on, and explaining that quite well, it makes it clear that the judges are reading and are aware of the press that's going on in the cases.
Well, I'd hope they are. I mean, I hope they're not cocooning themselves and not paying attention to what's going on in the real world. They have to be aware of what's going on.
Yeah, well, I guess just protecting judicial independence is kind of like one of my missions right now, is trying to make it safe for judges to acquit in cases where there's a risk of, say, a protest or, some sort of a mob reaction, and complaints being issued to the CJC and so on. But
I understand. I agree.
But so getting out of all the heavy stuff, or maybe it is heavy stuff, I don't know. Why did you originally get into law?
I was a reporter for a short time, and I decided the only thing more exciting than being a reporter was being a defense counsel. Really, that's really what it came down to. I was working as a reporter of a small town newspaper in Manitoba, and one of my beats was the police and the courts, and it was the head of the judicial district. So I covered a lot of court, and got to know the defense bar and the crown attorneys. A very small bar, and just enjoyed what was being done. And although I loved reporting and being a reporter in a newspaper, it was very exciting. You see your name as a byline on the paper, every day. The only thing more exciting was being a participant as opposed to just an observer. And it actually affects. I like to think that what I do actually affects the lives of individuals pretty much immediately. I don't know if I can practice the type of law where we're just arguing about money or corporations or things that aren't as critical as in the criminal justice system. It's interesting, it's exciting, and it has an immediate impact on human lives. So I like to think that I'm having that impact. It sounds very grandiloquent, but really that's why I do it. And frankly, I think that's why many, if not most, criminal lawyers do it, because it's interesting, it's exciting, and we have an impact.
Well, I can tell you from having started out just reporting on cases and investigating, what was happening in the legal system, that there was a sense of helplessness just reporting on it, that now that I'm actually doing research and directly contributing to individual cases, that it makes me feel less helpless, and I feel more constructive and more productive in terms of addressing injustices and so on. So I totally get, why you would want to make that move. And also it is like, you're just moving from case to case all the time. So it is always exciting. I find every case is almost like a movie I watched, that that has all of its intricacies. And that's one of the things I find frustrating, is that the reporting and the opinions people have about cases online, they don't know even a fraction of what's involved in the actual cases once you're there and you know all of the, like, if you attend the trial, even no, actually, if you attend the trial, you still only hear a portion, only what's allowed in court, a portion of what was actually going on in that situation.
Sometimes you don't get to hear the best parts, but not always.
I know. Well, those damn rules of evidence, hey? Well, it's always great to chat with you and catch up. And you really are one of my favorite people. And as I've said, I don't have many friends, so I'm glad to count you as one of them.
You're too kind, Danny. Too kind. Always fun. Call anytime. And all the best. Take care.